Assalamualaikum and very good morning to ladies and gentlemen. Today we will present about company winding up. Good day everyone and welcome to today's podcast discussion on company winding up under the Company Act 2016. I am Nur Iskandar acting as chairperson for today's session. Together with me are two invited legal experts, Adam and Krishan, who will discuss the legal procedure, types and implication of winding up in Malaysia. Today's discussion will focus on meaning of winding up, types of winding up, voluntary winding up, compulsory winding up by the court, role of liquidator, Malaysian case law, mini judgment and conclusion. Before we begin this discussion, it is important to understand why winding up is significant in company law. In business, not every company succeeds forever. Some companies face financial problems, management conflicts or business failure. When it's happened, the law provides a proper procedure to close a company fairly and legally. The winding up process protects many parties such as creditors, employees, shareholders and even customers. Without proper winding up procedure, company may avoid paying debt or misuse company assets. Under the Company Act 2016, winding up ensures transparency and fairness in ending a company operation. Let us begin with the first question, which is what is winding up? To start our discussion, let us focus and understand the meaning of winding up, why this process exists under Malaysian company law. Can you explain what winding up means under the company law?
Winding up refers to the legal process of closing down a company in an orderly manner and lawfully manner. It usually happens when a company is no longer able to continue its business operations, has achieved its purpose, or when the members of the company decide that it should stop operating. During the winding up process, the company's activities are gradually brought to an end instead of being stopped suddenly. This process is important because it ensures that all financial and legal matters are properly settled before the company officially ceases to exist. The main objective is winding up is to collect and realize the company's asset. This means that the company's properties, cash, investment, and any other valuable asset will be identified and sold if necessary. The money collected from this asset will then be used to pay off the company's outstanding debts and liabilities. The creditors such as banks, supplier, employee, and tax authorities are usually given priority when the payments are made. This helps protect the right of those who are owed money by the company. After all liabilities and obligations have been fully settled, the remaining balance or surplus will be distributed among the shareholders according to their ownership or shareholding in the company. Once this process is completed, the company will be officially dissolved and will no longer exist as a legal entity. This means the company can no longer conduct business, enter into a contract or own asset under its names. Under the Companies Act 2016, the winding up process is carefully regulated to ensure fairness, transparency and proper management of the company's affairs before termination. The law provides procedure that must be followed so that the interests of creditors, shareholders, employees and other stakeholders are protected. Overall, winding up is an important legal mechanism because it allows the company to end its operation in a structured and responsible manner while minimizing disputes and financial complications.
Yes, and winding up is important because it protects creditors, shareholders, employees and the public. It ensures the company does not simply disappear while still owning money. The process is supervised either by the court or through voluntary procedure depending on the company's financial condition.
For the explanation, Adam and Krishan, from the discussion we can see that winding up is not simply closing a business. It is actually a legal process supervised by law to ensure that all company matters are settled properly before dissolution. This process is important because company may still owe money to banks, suppliers, employees or other creditors. Moving on to the next question, which is question 2 on the types of winding up. What are the main types of winding up in Malaysia?
There are two types of winding up under the Companies Act 2016, namely voluntary winding up and compulsory winding up by the court. Both matters involve the process of closing down a company, but the difference lies in who initiates the process and the circumstances surrounding it. The first type is voluntary winding up. This occurs when the company itself decides to close down its operation willingly. Usually, the decision is made by the shareholders or the members of the company through a formal resolution during a general meeting. A company may choose a voluntary winding up for several reasons, such as business no longer being profitable, the company achieving the objective for it was formed, or the owner deciding to retire or move on to the other ventures. In some situations, company may still be financially stable and capable of paying all its debts, which is known as member voluntary winding up. However, If the company is unable to pay its debts, it may proceed with a creditor voluntary winding up, where creditors become more involved in the process to protect their interests. The second type is compulsory winding up by the court. This happens when the court orders a company to be wound up due to a certain legal or financial issues. Normally, the application to the court can be made by the creditors, shareholders, or even the company itself. One of the most common reasons for compulsory winding up is when a company is unable to pay its debts and is considered insolvent. Besides that, the court may also order winding up if the company has acted unlawfully, failed to comply with legal requirement, or if it is considered just equitable for the company to be dissolved. Once the court grants the winding up order, an official liquidator will be appointed to manage the company's assets, settle liabilities, and oversee the entire process until the company is officially dissolved. Overall, both voluntary and compulsory winding up serve the same ultimate purpose, which is to properly terminate a company's existence in a lawfully and organized manner. However, voluntary winding up reflects a decisions made internally by the company, while compulsory winding up is enforced externally through the authority of the court.
Voluntary winding up can further be divided into members voluntary winding up and creditors voluntary winding up. Members voluntary winding up happens when the company is still solvent and able to pay its debt, and creditors voluntary winding up occurs when the companies cannot fully pay its debt.
The distinction between voluntary and compulsory winding up is very important because it determines who controls the process. In voluntary winding up, the company itself decides to close down. However, in compulsory winding up, the court becomes involved because of serious financial or legal problem. And then we're moving on to the next question, which is question 3 on the voluntary winding up. Next, can you explain voluntary winding up in more detail?
According to the Companies Act 2016, a company can choose to end its business operation through voluntary winding up if the shareholders agrees that the company should no longer to continue its activities. To officially start the process, the shareholders must pass a special resolution during a general meeting of the company. This resolution is significant because it represents the collective agreement of the members to dissolve the company in a legal and organized way. Once the resolution has been approved, the company will begin the process of settling its affairs and preparing for dissolutions. In a member voluntary winding up, the company is considered financially healthy and still capable of paying all its obligations. Before the winding up can proceed, the directors are required to issue a declaration of solvency. This declaration acts as a proof that the directors have examined the company's financial condition and are confident that the company will be able to settle all debt within 12 months from the start of the winding up process. The statement must be made carefully and responsibly because it reflects the true financial standing of the company. The declaration of solvency is important because it protects the interests of creditors and ensures that the winding up process is carried out honestly. It prevents company from misusing the voluntary winding up procedure to escape liabilities or avoid paying debts if the directors become inaccurate information or make declaration without a proper justification. They may face penalties under the law. Because of this, the directors must ensure that all financial records and evaluation are accurate before making the decisions. After the declaration and resolution are completed, a liquidator will be appointed to oversee the entire process. The liquidator duty is to manage company's remaining assets, ensure debts are paid, and distribute any excess funds to the shareholders. When all matters have been finalized, the company will be officially dissolved and removed as a legal entity. This process ensures that the closure of the company is conducted systematically, fairly, and in accordance with legal requirements.
In creditors voluntary winding up, the company is insolvent. Creditors become more involved because their interests are affected. A meeting with creditors will usually be held and a liquidator may be appointed to manage the company's asset and debt repayment.
So the financial condition of the company determine which voluntary winding up procedure applies?
Yes, exactly. The financial condition of the company plays a very important role in determining which type of voluntary winding up procedure will be applied. If the company is dissolvent and able to pay all of its debts within the required period, it can proceed with members voluntary winding up. However, if the company is facing financial difficulties and cannot fully settle its liabilities, then a creditor's voluntary winding up will be more appropriate. So the company's abilities to meet its financial obligation is the key factor in deciding the correct winding up process.
This type of winding up allows companies to settle their affairs systematically. It also shows the importance of director acting honestly when declaring solvency because creditor may suffer loss if false information is provided. Now, let us discuss compulsory winding up by the court.
Compulsory winding up occurs when the court orders the company to be wound up under the Companies Act 2016. Usually, this happens because the company is unable to pay its debt.
Under the Companies Act 2016, a company may be subjected to compulsory winding up when the court orders the company to be dissolved. One of the most common reasons for this situation is when the company fails to settle its debt. In such circumstances, a creditor has the legal right to file a petition to the court requesting that the company to be wound up. This usually happens when the company owes money to the creditors but is unable or unwilling to make payments within the required time. If the court is satisfied that the company is insolvent and cannot meet its financial obligation, the court may issue a winding up order. When a creditor files the petition, the court will examine the financial position of the company carefully before making a decision. The purpose of this process is to ensure fairness to all parties involved, especially creditors who are trying to recover the money owed to them. Once the winding up order is granted, a liquidator will be appointed to take control of the company's asset and affair. This liquidator will then collect and sell the company's asset, use the proceeds to pay outstanding debts, and distribute any remaining balance according to the legal priority. Besides failure to pay debts, there are several other grounds that may lead to a compulsory winding up. One example is when a company acts against a public interest. This refers to the situation where the company's operation or activities may harm a society, violate public welfare, or threaten the interest of the public. In such cases, the court may decide that the company should no longer be continuing operating. And another ground is when directors are involved in illegal or fraudulent activities. For example, if the director misused company funds, commit fraud, or operate the business unlawfully, the court may intervene and order the company to be wound up. This is important because it helps maintain accountability and protect stakeholders from misconduct within the company. Compulsory winding up may also occur when the company is unable to continue its business operation effectively. This could happen because of several financial losses, internal conflicts, or failure to achieve the company's objective. In addition, the court may order winding up if it believes that it is just and equitable to do so. This means the court considers it fair and reasonable under the circumstances for the company to be dissolved, especially when continuing the business will no longer benefit shareholders or stakeholders. Overall, compulsory winding up serves as a legal mechanism to ensure that the company which are insolvent, unlawful, or unable to operate properly are dissolved in a fair and regulated manner.
The court will examine the evidence before making the winding up order. Once granted, the company must stop normal business operation except those necessary for liquidation.
Compulsory winding up is usually more serious because it often involves insolvency, unpaid debts, or misconduct. The court plays an important role in practicing public interest and ensuring justice for creditors. And we're moving on to the question 5, which is role of the liquidator. After a winding up order is made, an important individual known as the liquidator will manage the company affair. Who is the liquidator and what are their responsibilities?
A liquidator is a person appointed to manage and control the winding up process of the company. Once a company enters winding up, the authority to handle the company's affairs is transferred to the liquidator. This is important because company can no longer continue operating in a usual way, and someone must take responsibility for ensuring that the company's closure is carried out properly according to the law. Depending on the type of winding up, the liquidator may be appointed by the shareholders, creditors, or the court. One of the liquidator's main responsibility is to collect and sell the company's asset. The liquidator will identify all assets owned by the company, including cash, equipment, vehicles, property, and stock, and also investment. This asset may then be sold or converted into money so that the company's debts can be paid. The liquidator must manage the process carefully to ensure that the assets are handled efficiently and that their value is not wasted. In addition, the liquidator is responsible for investigating the company's financial affairs. This includes checking accounting records, financial statements, and past business transactions to understand the company's financial position. The liquidator may also examine the conduct of director and officer to determine whether there has been fraud, negligence, misuse of company funds, or any unlawful activities. If any wrongdoing is discovered, appropriate legal action may be taken against the responsible parties. Another important duty of the liquidator is to distribute the company's money fairly among the creditors. Creditors are all not paid at the same time because the law provides a specific order of priority. Certain creditors, such as secured creditors and employees with unpaid wages, may receive payments before unsecured creditors. The liquidator ensures that these payments are made fairly and in accordance with legal requirements. If there are still money remaining after all debts have been settled, the remaining balance will then be distributed to the shareholder based on their shareholdings.
The liquidator also ensures that directors do not misuse the company's asset. If fraud or misconduct is discovered, the liquidator may report the matter to the authorities or court.
The liquidator acts independently throughout the winding up process and must carry out their duties fairly without taking sides. This means the liquidator cannot favor certain individuals or groups when managing the company's affairs. Instead, they are responsible for ensuring that the entire process is handled professionally and according to the law. At the same time, the liquidator must protect the interests of both creditors and shareholders. Creditors need to be treated fairly so that the company's debt can be settled properly, while shareholders also have the right to receive any remaining balance after all liabilities have been paid. Because of this responsibility, the liquidator must make a careful decisions and ensures that the winding up process remains transparent and well managed.
The liquidator duties are very important because they ensure that company assets are not hidden or misused. A professional and independent liquidator help maintain trust in the winding up process. So we're moving on to the question 6, which is Malaysian case on the chat. To better understand how winding up principles are applied in real situation, let us look at Malaysian court case. Can you provide a Malaysian case related to winding up?
One important Malaysian case is the Tan Kim Hor and Anor against the Tan Gik T and Anor 1991. In this case, the court discussed the just and equitable ground for winding up. The relationship between shareholders had broken down completely, making it impossible for the company to operate properly.
The court decided that winding up was the most appropriate solution because there was a serious loss of trust and confidence between parties involved in managing the company. In a situation where the relationship between shareholders or directors becomes strained, the company no longer to be able to operate effectively. Constant disagreement, conflicts, or lack of cooperation can affect decision making and create difficulties in managing the business properly. This case demonstrates that the winding up is not only related to the financial problems or unpaid debts. In certain situations, the court may order a company to be wound up based on fairness and justice, especially when the internal relationship within the company has broken down completely. Therefore, the concept of just and equitable to do so, winding up allows the court to dissolve a company when continuing the business will no longer be fair or practical to the parties involved.
This case demonstrates that winding up is not limited to financial problem only. Sometimes serious disagreement between shareholders may make it impossible for the company to continue operating effectively. So we're moving on to the question 7, which is mini judgment. We will now conduct a short mini judgment session to stimulate how judge may decide a winding up case in court. Assume a company pay creditors for several months and shareholders are involved in serious internal dispute. Should the court order winding up?
After reviewing the facts of the case, the court found that the company was unable to pay its debts, which indicates that the company is insolvent. This means the company does not have enough financial resources to meet its obligation to the creditors. At the same time, ongoing disputes in the management have also disrupted the company's daily operation, making it difficult for the business to function effectively and make proper decisions. Under the Companies Act 2016, the court is given the authority to order compulsory winding up where the company is insolvent and cannot continue its business activities in a stable manner. The law also allows the court to intervene when it is considered just and equitable to do so. This includes situations where internal conflicts, breakdown of trust, or management issues make it unreasonable for the company to continue operating. In this case, both financially inability to pay debts and the serious management disputes support the court's decisions to proceed with compulsory winding up.
The court therefore grants the winding up order and appoints an official liquidator to manage the company's affair. This decision protects creditors and ensures fair distribution of company's assets according to the law.
So, in conclusion, winding up is an important legal mechanism under the Company Acts 2016 to properly close a company and protect stakeholders. So, today we just discussed meaning of winding up, types of winding up, voluntary and compulsory winding up, rule of liquidator, Malaysian case law, and many judgment. Thank you for our invited expert Adam and Christian for their valuable discussion, and thank you everyone for listening to this podcast session. It's all from us today. Thank you.